The following is a pre-recorded show. Welcome to Winning in Retirement with your host, Brian Akers, certified financial planner professional and founder of Akers Financial Group. Now, helping you win in your retirement, here's Brian Akers.
Welcome to Winning in Retirement. I'm Brian Akers, president and founder of Akers Financial Group. Here with me today, I have attorney Kevin Bress. Kevin Bress is from Bress Route Law Firm out of Bel Air. Good morning, Kevin.
Good morning, Brian.
Have you done this before?
You know, I was thinking like they do on Saturday Night Live. This is like my fifth time being asked to be a guest.
Yeah, exactly right, to be on the radio show with me. But have you ever been an attorney before? Is this your first day being an attorney?
40 years
Oh, wow.
year.
Congratulations on 40 years. That's awesome. And you've been practicing in Maryland your whole time?
Well, I'm more than practicing. I'm actually doing
You got it down now.
Yeah.
That's like an Iverson quote. Practice? Yeah. Well, I love the concept of practice. It's fun to talk about. The thing that we want to do is have a great radio show. That radio show is by bringing in experts like Kevin Bress. We can actually nail them to the chair, tie them down, and then ask questions that we all want to know the answers to.
And not get a bill.
How did you figure me out already, Kevin? All right, so the idea is this today. Our topic is legacy and charitable giving. I'm Brian Akers. I'm a certified financial planner. I'm not a lawyer, but we have a lawyer with us. Now, Kevin, you and I have known each other for a long time, but today is a very special day. Do you know why?
I'm waiting.
I don't know either. I was hoping you knew why. Oh, actually, the reason it's a very special day is that we're talking about successful people and what they do with the wealth they accumulated, and how your wills, your beneficiaries, all these things are out there available to you to make things happen the way you want to make it happen. To be scared and nervous about planning for your death is not a bad thing. It's a good thing. It's a proactive thing. And so the concept for today is, if you want to think about legacy planning, all we're talking about today is planning and getting ready to do things. That's part of a legacy by itself. So have you enjoyed throughout your career helping people plan and reach their goals?
Right. And over the years, Brian, you hear people say certain things over and over again, and you start to chuckle to yourself. So people have trouble grappling with death. So they say, if something happens to me.
Yes.
And
right.
They don't say when I die, they say if I die.
Correct.
And then I tell them what the death rate is in Maryland. I don't know if you know.
I do not have that one memorized.
100%.
Oh, I'm sorry. Not for this year.
No,
yes, 100%. Yeah, that's a lawyer joke, right?
It is.
Okay.
Not funny.
Didn't really recognize the lawyer joke, but I get it now. All right. So because we know there's death, there's taxes, and those are very, very things are going to happen during our lifetime. We know that. The hardest part, though, is to talk about it. And so in planning, the way I like to mention it is this. We plan for all the worst case scenarios. We get those lined up, what you want to see happen, get it organized, and then go do everything else that you enjoy to do. Go make your investments and enjoy and retire, win in retirement, and don't have to think about it again once we have it established and set up, right?
In all honesty, Brian, when clients are finished, they have a big smile and they say, I am so glad I got this taken care of.
So
they really do.
It's more of a burden, right?
Yeah, it hangs over them, but they don't do anything about it for 10 years. And then finally, they're resigned to the fact that it's behind them.
Yeah, so the idea is this. Legacy and charitable giving is our topic. So I'm going to intertwine my questions for the lawyer we have here, Kevin Bress. Now, Kevin, you have a partner, Ashley Nelson Rout, and you have a law firm in Bel Air. And it's called Bress Route Law?
Exactly. A little boutique, we like to call it.
And that's actually your website too, right?
Yes.
At Bress Route, RAUT, law.com, right?
Correct.
Cool. And that's the way to reach out to find information from Kevin. And at Akers Financial Group, you always reach us through our website also at akersfinancialgroup.com. All right, this first thing I got to do, I got to cover a little bit of this new law that came out July 4th. They call it the One Big Beautiful Bill Act. I call it OBA. So if I use the word OBA, it's not an instrument. It's going to be the law that came on July 4th. I believe the law does something good for your industry in the fact that it made the federal estate tax permanent, the federal estate tax exemption permanent at $15 million. $15 million means that people don't pay tax on giving money to the next generation. But can you explain what a federal estate tax exemption is so we can all understand and how it all works?
Well, when a person dies, you are supposed to total up everything they have.
Sure.
And there's sort of an over-under. And now it's $15 million, which pretty much keeps most of us under.
Right.
If you're under that threshold, you don't even have to file for the estate a tax return. It's, as I like to say, it's like catching a fish and it's too small. The federal government throws it back.
Right.
So it's virtually a non-issue for 99.9% of the population now.
Okay. And that's federal, and that's per person. So it's $30 million for a joint.
Correct.
For a married
two spouses.
Two spouses, it would be $30 million. And that's a permanent in this new law. It's not a 4-year exemption like all the extras that were thrown into that law. It's really a permanent thing. Now, Maryland is different than the federal, and it's been different over the last few years, separated itself from the federal exemption limit, and it's like $5 million. And how is that different? How would you explain the $5 million versus the $15 million?
And Maryland is identical to the feds, except that the threshold is so much smaller, $5 million, but it's 5 plus 5 for a married couple. But there's a very key difference here, Brian, and that is that Maryland does not have a gift tax. So a lot of people get hung up on the gift tax. Oh, I want to help my child buy a house I'm going to give them $100,000.
Sure.
Do I have to pay a gift tax? No, the $15 million exemption applies to gifts and death for federal. So that's exempt. But then they worry, I have more than $5 million. Am I going to end up paying a gift tax to Maryland? And the answer is there is no gift tax in Maryland. So give them all you want.
So gift tax is while you're alive.
Correct.
And state tax is you've passed away. You died.
That's right. So federal would add up what did you give away plus what did you die with.
Okay. Now, over the limits, there's taxes, estate taxes, and then Maryland has some other taxes we'll talk about later. But generally, estate tax would be pretty hefty above $15 million, and that number has been in the 40% range for a long time. But the idea is that you can actually give to charity, you can make your beneficiaries be your kids, but you don't really avoid the estate tax unless you give to something like a charity, right?
That's an exempt gift.
That is an exempt
or an
gift.
exempt bequest under a will.
Under a will. All right. So basically what we're saying there is this. If you have an estate that happens to be $15, $30 million and you want to give $15 or $30 million based on married or spouses, what you can do is then have that go to them. But above that level, you have to do other planning. And one of that is possible charitable planning.
And I'm seeing an uptick, Brian, in people now. They're thinking charities in their bequests. This week, I had somebody who went big on some charitable gifts. I was really pleasantly surprised.
Charitable gifts today or in the future?
In the will.
In the will, okay. And what's great about that is that can be your legacy. What you really want to try to accomplish during your lifetime can also be carried through upon a death. In that if you give while you're alive, you might want to continue to give at the final reckoning, the final day, right?
Right. It's just a question of picking your favorite charity. And then some people want to have some recognition for it. Like I want it to be used for X, or I want to establish a scholarship at a college, that sort of thing.
Sure, exactly right. And so organizing that, having that written down, and then funding it properly is all very, very important. Because I've seen where people have that in their will, but then they bypass their will with all their assets, and there's nothing to fund it inside their will. That's
what we in our industry call malpractice.
Okay. Yeah. So the hard part is when you have maybe your investment person or insurance person, they might not care about the beneficiaries as much as your lawyer does. And so your lawyer is working on the flow and how to process it, how to get it to the right way that you want it. But then a beneficiary could just be filled out very simply, and I might put your kids down where you didn't really want to give it to your kids. You want it to go through some type of custodial or some type of trust upon death, or you want part of it to go to charity, then the rest of the kids. Whatever sophistication you add, you got to make sure the money flows through all that too, right?
Right. When I schedule an appointment with a new client, I mail them an asset schedule, and I say, please sketch out your holdings. And a lot of them will come in and say, well, here it is, but I'm not taxable, am I? And I said, well, it's not just about the tax. It's what you're saying, Brian. It's about knowing the money will get to the charity or the people the way you want it to.
I use the word estate flow. A flow is really drew all this up, and this is where it's actually going based on what you drew up. Is that what you want? Is there a fancier word than flow that the lawyers use?
No, in fact, I think I'll trademark that. That's a good word.
You like that word? Okay. Well, the idea is this, is when someone passes away and we get that phone call, then we would sit down with them and we go through things and guide them on what to do next and meet with the kids or beneficiaries or whatever and help them with paperwork. It is a process, and it is very, very good when people, as part of their legacy, that they did the actual planning. The sad part is most new clients, no matter if they have investment advisors or not, come in without any planning being done at all. And that's probably been normal throughout your career is people come in with no planning, right?
Oh, yeah. It's surprisingly 50 years old, 60 years old.
Yeah.
And they're embarrassed. They say, I'm really embarrassed. I say, well, look how much money you saved by not doing it up until now. But
you got away with it. Congratulations, you got away with it, right?
Right. But it's time. It is definitely time.
Well, and that's one of the things we want to try to get across today is, yes, you want to build a legacy. You want to have charitable giving. Well, why not do it today? Why not take time and organize yourself to make sure that the legacy of planning is your legacy? Do we have to wait to a certain age or a certain dollar amount? The answer is no. What we got to do is think about what you want to accomplish, what you want to do. And if we also have to start planning as if we might die tomorrow, which not a fun thing, right, Kevin?
No. And when do you start? Age 18. Nobody starts at age 18.
Right.
Theoretically, you could start at age 18 thinking about it.
Right. So that's a good advice, I think. Is when you hit 18, you got to have some type of plan. I like at age 18 for them to actually give people the ability to be their power of attorneys, cause of disability, and all these other pieces that are added to the estate plan, right?
Way more important than the will, because most 18-year-olds don't have much to worry about.
Yeah, so today's show is going to be about legacy and charitable giving. This show is called Winning in Retirement, and all part of that winning in retirement is getting everything in order. And the best thing about retiring, when you have everything in order, is that retirement, your time becomes your time. You get your time back. You decide how to use it. Before retirement, your time is tied up with other commitments, like mainly your job. A lot of that goes away in retirement. Your time is now consumed by things that you want to do. It's so easy to begin winning in retirement. You go to our website at akersfinancialgroup.com, scroll through the schedule a meeting section, and let us know you'd like to schedule a free consultation with one of our team of advisors. That's akersfinancialgroup.com, or you can call us at 833-WIN-RETIRE, 833-WINRETIRE. We'll call you on Monday to schedule a free in-person meeting. Go to akersfinancialgroup.com or call us at 833-946-7384 to start planning for your retirement now. Who is your most undesired beneficiary? We'll talk about this when we return.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Welcome back to Winning in Retirement. I'm Brian Akers from Akers Financial Group. I'm president and founder. I'm a certified financial planner practitioner. Along with my team of advisors we have at Akers Financial Group, we look forward to sitting down and talking with you about your situation and how to help you win in your retirement years. Part of that process is talking about the bad things in life, the worst case scenarios, making sure that what we want to happen happens with our money. Make sure these things are really there for us, are built to be for you for the rest of your life. So the important thing that we like to do is we like to work with attorneys, and we just happen to have one strapped into the radio chair with us today. We won't let him leave until we get all the answers out of him. Kevin Bress from Bress Route Law. Good morning, Kevin.
Good to be here, Brian. Thanks for having me.
I'm glad you came back for the second quarter.
Yeah.
First quarter wasn't too bad.
Yeah, I'm looking forward to halftime, too.
We take one quarter at a time. I've just got to pace it out. All right, so this time I asked a hard question. I want to see how you would answer it. All right. What is your most undesired beneficiary? So when you think about that question, your most undesired beneficiary, what goes through your mind as an attorney?
Well, it's an heir, a person you never expected would get your money.
Okay.
And you're floored that they do.
Is that like the accidental beneficiary type thing?
That's exactly, yeah.
And that is, how would that happen? Have you ever seen it happen?
Yeah, it's where a very simple example would be a divorced mother, let's say, leaves the money to her only child, all her money.
Sure.
The only child is 18, 20, 22, not married, no kids, no will. And heaven forbid, that only child dies in that status, who gets the money? The ex-spouse, the divorced husband collects from his child.
Because the mom passed, went all to the child, and then upon their death, it went that way, right?
Next closest relative is not the brother or the sister, but the parent.
Yeah. And that's because of you give your wealth to the next generation, and they're not ready to receive it. They haven't done the planning or the legacy.
That's right. And it wasn't expected, at that young age. But my job is all about the unexpected.
Absolutely. So the question is, who is your most undesired beneficiary? So I was thinking about it could be, things in the will. You might have somebody written in your will. It could be like, say you wrote a will when you're younger. It could be your sister, and then you've been married for 25 years and you never changed it. It could be something like that. But I have my own answer as a financial planner. Do you want to hear my answer?
I'm all ears.
Sorry, we're not going to joke about that too much. But the idea is this. The most undesired beneficiary, as a financial planner, I think that is undesired, is the fact that Uncle Sam and taxes can be waiting for you in many different forms. And so you think about, I'm going to give it to my nephew, to my niece. I'm going to give this money to all these different people. I'm going to give my friends some money. I'm going to spread it out. Everyone is treated differently when it comes to taxation, especially when it comes to Maryland. And what I'm trying to get at is there's different kind of taxes. The taxes when we pass away, there's something called estate tax, and then there's something called inheritance tax, right, Kevin?
Right. Maryland. So when you said Uncle Sam, I'm thinking federal.
Well, I didn't know what to call Maryland.
Maryland is Uncle Wes, right?
Currently,
he's the guy in Annapolis right now.
Sure.
But it actually goes to Uncle Derek, because in Harford County, we have Derek Hopkins, the Register of Wills.
All right.
So there's a 10% tax on nieces and nephews, but their parent, your brother or your sister, is tax-free.
Sure.
So this is what we have to talk about with people. Do you care that 10% haircut goes on it because you're giving it to your nephew, or do you want to try to work around that?
Right. Is there a workaround?
Give it to the brother or the sister with a handshake, wink, and a promise that they will give it to their child.
Okay. So if you really want to benefit the niece or nephew, you can give it to your brother and sister, then hope they do that.
That's right.
Okay.
That's not a real solid estate plan, Brian, but that's my best quick answer on that.
So an inheritance tax is who pays inheritance tax generally?
It's supposed to be the recipient pays. They get a bill from Maryland, but most 99% of the wills will say my estate will pay the tax so that the recipient doesn't have to get chased by the state of Maryland to pay the 10%.
Okay, that makes sense. Now, the people, so if we give money to our kids, will they ever pay inheritance tax in Maryland?
As you mean, give a gift before they die?
No. After you pass away,
right?
There's a gift. Is there a certain size limit, anything like that?
$1,000 for inheritance tax. That's it.
That's it. Okay.
Yeah. If they're you say children, they're tax free.
They're tax free, no matter how much we give them.
No matter how much on the inheritance tax.
But there's estate tax.
The estate tax we talked about $5 million.
Yeah, right. Yeah. All right. So the other surprise taxes are the fact that if you have something that's not been taxed during your lifetime, like an IRA or a non-qualified annuity, those things come out as ordinary income and income taxable to the beneficiary as they take money out. That's a really good thing. Then there's this wonderful step-up in basis on a lot of items, which is actually a very good thing. Step-up in basis is for real estate, where basically the date-of-death value is if you sell it right away, there'd be no capital gain at all. And then same thing with stocks, things like that have a step-up in basis upon death. That works out pretty well for them not paying income tax upon a death.
And here's when it backfires, Brian.
Sure.
Somebody without advice says, oh, my son lives with me. He's my only child. I'm going to sign my house over to my son so I don't lose it to a nursing home or something like that.
Right.
Mom dies. Son says, okay, I'm not living here anymore. I'll sell the house. Bang, rude awakening. Big capital gains tax could have been avoided if she didn't give it away before death.
Right. And so that happens a lot where people, I'm just going to add my name to my parents' house. It's going to help them out. I'm going to avoid the process that way by adding their name to the deed. Is there another way?
It's something called a life estate where the parent retains life ownership.
Sure.
But the child's name is on the deed as a beneficiary. We get the step-up basis that you just spoke about.
Sure.
Tax-free on capital gain sale.
Is there any other way in Maryland to do that?
A trust.
A trust. Okay, so a trust could do that. There's no beneficiary form like transfer on death.
Not yet. The legislature's trying to pass it. But.
Sure. Okay. So that hasn't officially happened. All right. So what he just brought up is very important. In fact, that don't do things quickly without advice, especially on a big item. It sounds simple, like you add your name to a checking account, you add your name to a house. Why not add your name to all the things, thinking it's going to be simple? Adding to a checking account, what's the issues with that?
Well, everybody worries that their checking account will be in jeopardy if the joint owner gets into some financial jackpot.
Right.
In reality, that's pretty rare that happens, but I have to tell them both sides of the story.
Sure.
So, but I do like joint accounts with, especially people up in their 80s.
Yeah.
Don't rely on a power of attorney for something as simple as a checking account. Just put their name on it is how I feel.
Yeah, that sounds really good. Now, gift taxes, what we said in the first quarter was there's no gift tax in Maryland, but there's a gift tax on federal. And that is if you give somebody more than $19,000, there could be a gift tax, right?
Well, over 19,000 means you're now going to start using up your 15 million.
And using
but until you use that up, there's no gift tax. So
but you have to do a form, right?
You're supposed to keep Uncle Sam informed, correct, of your gifts above 19,000. But the bottom line of that form is going to be zero until you exceed $15 million.
And you should file that form and then keep a record of that form.
Yeah, because they lose it at IRS. They do lose the gift tax forms.
Possibility, right?
They do.
Yeah. All right. So it's a burden of proof, the thing, is you got to make sure you keep that.
That's right.
Now, the reason we're talking about this undesired beneficiary is you give an IRA to someone and all of a sudden they get it and then they have this new 10-year rule. But the problem is they got to pay tax on it. And so the 10-year rule allows us for the beneficiary through beneficiary deferred accounts to spread money out over time and pay tax within certain tax brackets. So do more income planning and avoid some of the taxes. The hard part is there are taxes. That's why I love the idea of giving life insurance. I love giving Roth IRAs, things like that to the kids, all tax-free. I like IRAs, traditional IRAs, to go to charity. Now, making a charity a beneficiary is something that I enjoy doing. Have you seen other ways to give the charity for their people's accounts, and how does that work for you? Well,
I agree with you. The IRA, taking an item that would have been taxable to the recipient,
sure,
and you wanted to give, let's say, $10,000 to the church, make them the beneficiary of a $10,000 value,
sure,
and the government's not included.
All right, so that's one way to avoid taxes is by giving the charity. One way to lower your taxable estate is by saying, well, we're going to give a certain amount to the family, and everything above goes to charity. And that's a way of trying to alleviate future possible tax, especially if you have a high net worth situation, right?
Right. They'll give the children up to the tax limit and the charity the balance. And they figure children are getting enough.
Yeah.
And there's actually a way, Brian, we might get to it the next quarter, is how the children can still control the charitable bequest after death of the parent.
Do you want to slide a little bit of the answer this quarter in case somebody falls asleep or anything?
Well, in the old days, it was foundation. I'm going to set up a foundation.
Private foundation, right?
Private foundation. Now the government has allowed for years, and people still aren't aware of it, something called a donor-advised fund. The donor being the parent, and the fund being the substitute for a foundation. But it's free. It's completely free. The lawyer's sitting in the chair, not doing anything. They're wishing they had some work to do. There's no work. The accountant, no accounting, no taxes, no reporting. So donor advised fund. We need to learn more.
Donor advised fund. We'll go into more detail and later on in the show today. But the idea is to be able to give the charity. The only caution on charity would be to have a charity beneficiary and then add people to it. It does cause some problems on the 10-year payout rule for spouses and stuff. So a lot of times we'll have an IRA that's set up for charity, be separate from the ones you want to give to individuals.
I agree totally.
Simple ideas like that.
Yep.
All right. So, this quarter's flown by. So our topic this last quarter is who is your most undesired beneficiary? It could be anybody you thought of when we asked the question. And also it could be taxes, where there's these taxes that people are going to pay. And you might not want that to happen. And that's why we do financial planning at Akers Financial Group. That's why we bring in lawyers to handle the actual writing up of everything that's needed to make sure things happen the way you like. At Akers Financial Group, we're local. We're independent. We don't report to a big company on Wall Street. We report to you. We do have offices in Forest Hill and Lutherville, clients all around the country, and even a few around the world. It's so easy to begin winning in retirement. Just give us a call and schedule a free meeting with one of our team of advisors. Call us at 833-WIN-RETIRE. That's 833-WIN-RETIRE. We'll give you a call on Monday to schedule a free in-person meeting. Go to AkersFinancialGroup.com or call us at 833-946-7384 to start planning for your retirement now. When is the right time to create your legacy? We'll talk about this when we return.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Indeed. Welcome back to Winning in Retirement. I'm Brian Akers from Akers Financial Group. This is our Winning in Retirement radio podcast. Here with me today is attorney Kevin Bress from Bress Route Law. Kevin, you ready to go second half?
I'm suited up and ready to go on the field, Brian.
I'm glad you're suited up. That's always a good thing. The lawyers always seem to be suited up, but some are becoming more casual recently. What's your dress code like at your law firm?
No jackets.
No jackets.
No ties.
I totally agree with that. It's been a hard thing, jackets, but there's a new modern jacket that came out, has a flexible material I like a lot.
Oh, I thought you were going to say it's reversible and it has like the Ravens logo on the inside.
That's only on Fridays, right?
Yeah.
All right. So the show is called Legacy and Charitable Giving. So what we want to talk about this quarter is this. When is the right time to create your legacy? Now, we don't want to make legacy sound so unattainable or only for the limited 1%. We want to talk about what does this mean? So, Kevin, when I talk about legacy with you, how do you get this out of a client? How do you find out if they have things that they really care about? What goes on as a lawyer when you're working with people?
I think of legacy, Brian, as not only leaving the money to somebody,
Sure,
but ensuring or at least working toward it going to the next level and then the next level. So that's like grandchildren or even great-grandchildren. How do you best position the money that way?
Sure. And so the concept is almost like a beyond the grave concept where you pass away, you still control that money beyond.
And I'll hear that right out of the mouths of clients. I'm not trying to control it from the grave. And I say, well, then your son-in-law will control it. Wait a minute. Why my son-in-law? Well, you leave it to your daughter and she passes, and who is likely to inherit your money?
Right. Is going to pop right over to the spouse, right?
That's right.
Because people have I love you wills, right?
Whether they do or don't.
Yeah. Do you call? I'm sorry. Do you still call them I love you wills when it's?
I haven't seen that in ages.
Oh, come on.
Yeah. No, you're dating ourselves, Brian.
I'm young. I've only done like 37 years. You've got your 40 plus years. But the I love you will was, dear, here's everything, and then back and forth, and they list no one else after that. And it's just a mess if one passes away because then they don't change anything. And then you got to fix everything after the fact, which is just one of the problems that's been created for many, many years. But a simple I love you will, saying to your spouse, here's everything, that transfers everything to them, and then they control everything it goes to. That gets harder when there's a second marriage or a third marriage, something like that. So there's a lot of issues on legacy depending on your current setup, right?
Right. And there's a magic little theory of using something called a trust that takes care of it. But people don't know what a trust is. They think it's complicated. They think it has to go to some corporation and in the big city or something. But no, it can be out of your kitchen.
Sure. What do you mean by that, out of your kitchen?
Well, a trust can be managed by a family member without outside control at all or oversight.
Are trusts something that many people should look into or something that's used for certain reasons?
Well, it certainly fits into your definition of legacy.
Sure.
And the reason not to do it is I find people say, I don't have enough money for a trust. Mm-hmm. Well, if you have a disabled child and you just want to put $100,000 away for that person, is that that's worth a trust.
Absolutely.
Regardless of the money. So,
Right.
or if all you have is a nominal amount, you want it in trust for that child who has issues.
Absolutely. Yeah. So my thing is legacy and purpose of the money. So who do you want the money to go to, and when and how? How do you want them to use it and spend it? And do you want to have any control over that? That is designing a legacy plan. Legacy plan can be as simple as whatever I have left is going to go to them. Now, when you start thinking about everything you have left, you count your life insurance, your real estate, your investments, collections, personal property, vehicles, all these things. They all need the ability to transfer title. And there are many different mistakes that are done when people are trying to build a legacy, and then they sort of build a legacy without building a legacy at times. It's sort of like, oh, someone passed away suddenly. We need to figure it out. I hate those situations.
Well, and it goes back to that laundry list of everything you own, and you're hitting on it, Brian, to say, how does the car get to the child? They have to go through the government, or did you do a form online with MVA and it goes instantly? So.
Sure. Yeah, and that's a really great thing through the Maryland MVA, that you can add a beneficiary to your vehicle. You don't need to write it on the title or anything else, or make it join on the title now. You can just go through their website, pay $20, I think it is right now, and you fill it out, and you have a beneficiary on the title.
And you might need that for your own spouse. You have the pickup truck, and the spouse's name's not on it.
Yep, absolutely. And that's always been the rule, right? You put the car in individual name, house, and joint name.
That's right.
For liability purposes, right?
Another show I see coming.
Yeah, we're not going to get too deep into that. But so the idea here is this. You want to create a legacy. Guess what? The planning is part of the legacy. The fact that you did a plan is a wonderful thing. I had a meeting about a year ago with a client after the mother and father passed away. All the kids came in for like a family meeting to go over what the parents left. The parents were people that saved their money. They never made a lot of money, but when they built it all up, they were over $1 million in savings throughout their life that was there for their kids to receive. And so the meeting was a talk of their legacy of saving and being frugal. It was a meeting of what to do now with the different assets that they were giving, because each account had its own process. But it was a process of basically them really understanding how hard their parents worked. And the result was this next legacy, this gift after they passed away. And so the idea of that legacy occurring was a lifetime of saving money, a lifetime of doing the right thing. But one of the best thing they did was to have people put it together. We had wills, we had the things, beneficiaries done right, the titling done right, so it all could transfer to them as easy as possible. And so that to me was a pure legacy idea.
Oh, that's the A+ planning. Yeah. That's right.
That's not normal, though.
That's not normal, no. And it even goes beyond that, Brian. You and I are most dealing with the asset side of it, but there's so many other things to deal with. The dog, and where are the keys hidden, and how do you, what are the plants?
Well, digital assets is one of the biggest changes, right?
Digital, yeah.
And now, what do people need to do with their passwords and their websites and things like that? Because if you pass away immediately, how does someone have access to all that?
Right, and that's the easiest thing, is pass along the passwords, but they change all the time.
Sure.
So what lawyers are doing is putting in powers of attorney a language, and putting in the will language that says, hey, if you're locked out,
sure,
you have authority to get a hold of Google or the online bank or whatever,
sure,
and try to access some of the data in that online account.
So that would be redoing a will to be able to make that happen?
If that was important to somebody, I have yet to have anybody say, I want this in my will,
right.
but I routinely just add it anyway.
Oh, what if it's something they never thought about?
Exactly.
Because that's sort of the battle we've had in our careers, is what's the worst case scenario that can draw us off the plan where it's not going to work right. And having the digital assets, what I mean by that could be your digital accounts, your digital coin, whatever you have needs to have its own document to handle it.
I had clients last week getting up, ready to leave. We finished all the estate plan. I said, by the way, do you have any pets? They sat back down.
Yeah.
Yeah.
Right. Because pets need to have what's going to happen for a worst case scenario. Worst case scenario is you pass away tomorrow. What happens? Who can help?
Yeah, and are you going to give them a little money to help?
Right, actually, very true. All right, so we've been talking about like husband and wife. Let's talk single. Single with kids, single without kids. What's some general advice on planning for all that?
Well, the challenge there, Brian, is sometimes not having a will results in the same outcome as having a will when it's a single person with a child, for example. The child's going to get it all if there's no parent living. So then they ask me, well, then why do I need a will? And then I say, you got to go, what if? You got to go a step further. What if your child's not living?
Sure.
Who's going to get it? And I tell them it's their sister. What? I don't want my sister getting anything. Well, then you better have a will.
All right. So, because that's dying without a will, and that's intestate?
Yes.
And so can you just do a brief explanation of who gets that?
It's not the state of Maryland, and that's usually the first reaction people have is if I don't have a will, the state takes my money. In order for the state to take your money, there must be no living descendants of your grandparents. So we're talking.
Say that one more time. No living descendants of your grandparents.
So that includes cousins or children of cousins, meaning once removed. So if that whole line of descent is zero, guess who's next? Stepchildren are included, but only after everybody else. And then finally the Board of Education becomes your beneficiary.
All right. So say that again, my grandparents.
Descendants, people born to your grandparents. And you have grandparents on two sides.
Correct. Right. So you got to draw the lines out, do a little family tree.
A big tree.
Get them all written out. Maybe put them on your wall, put pictures next to them all. And you can say, that's my intestate will.
Yeah,
they get it all.
Cousin Louie is getting some money.
And then you look at the wall every day and you say, I don't want Cousin Louie getting my money.
And he's throwing darts.
I need a will.
At the wall.
Yeah. Well, all right. So I think it's funny to watch movies and how they interact with wills, the reading of the wills, and how they get offset and how...
No such thing as a reading of the will.
I've never been to a reading of the will.
And there isn't one. I've been to it. We've had them, but
we have family meetings and go through what happened. I try to have them so that we can plan ahead rather than post where they all of a sudden, hey, look what you're getting now.
Excellent point. And I'll have clients say, should I bring my children to the final meeting when I sign the will? I said, absolutely. Feel free to do that. That's so good.
Yeah, especially if you're ready to.
Yeah.
Now, if you tell your kids about your money that they're going to come knocking asking for it all, you might want to wait a little bit. It also gives you a sign on how you should do your planning too, right?
Yeah, and you have to ask how old the child is. When they came in with a pacifier screaming, I thought I should have asked how old they were before I said bring your children with you.
That's true. Well, this quarter's got flown by. We've been talking about the right time to create your legacy, and the answer we came up with is right now. The planning is part of that legacy. Now, at Akers Financial Group, we love to help you win in your retirement. The way we do that is we have a team of advisors that are ready to sit down and talk with you about your situation and help you with your unique financial fingerprint that determines where your money goes, how you set up your beneficiaries, how you bring in the attorneys to make your planning work for you. So go ahead and sign up for a free meeting with one of our team of advisors by giving us a call at 833-WIN-RETIRE. Schedule an in-person meeting with one of those team advisors by calling 833-WIN-RETIRE. That's 833-946-7384. Or visit our website at akersfinancialgroup.com. Scroll down to the button on our homepage and schedule a meeting right there. All right. What does your beneficiary form say? We'll cover why this is so important when we return in a moment.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Welcome back to Winning in Retirement. I'm Brian Akers from Akers Financial Group. Here with me today is Kevin Bress, an attorney that we have strapped down in the chair today to ask questions. We've been hitting them hard. The reason we're hitting them hard is because, Kevin, I believe this is a free hour of your time, right?
Check your mailbox on Monday.
I'm sorry, I forgot about that. Every 6 minutes, I keep hearing a ding. There's been a ding every 6 minutes in this, and they're doing the show, right? So I think. I'm sorry, that's funny. So the idea of lawyers, they charge fees. Now, some people charge one big set fee. You generally charge by the hour. Is that pretty fair to say?
No, actually, I will quote a flat rate because I don't want people to fear the hourly interaction. I don't want them to be afraid to call or change something.
Yeah, because hourly, the mental side of that is where you would think, well, all right, so they're going to go slow, take their time to run the hours up. A set fee is a set fee.
It is. And if it's a good, reasonable set fee, which I have to say, that's the secret. If you have a good, reasonable fee, the clients are happy.
Right. And so having a good balance, because the idea is this, there's a team when it comes to your financial advisors. There's a financial advisor, there's the accounting side, and there's the law side, or just some of them. We also talk with a P&C, the property and casualty insurance agent, to make sure it all works well together. Now, generally, the certified financial planner is sort of like the day-to-day coach, running and bringing in experts for different situations, getting the game plans in. Would you consider a lawyer being a defensive coach, or it's more defense, not an offensive coach, right?
Wow, we're getting into the analogy here deep, but it's being able to play both sides, offense and defense.
So it's more high school football then. You play both sides of the ball. Okay,
yes.
All right, that's good. So today's show is legacy and charitable giving is what we've been talking about, and this one topic I'm going to bring up is what does your beneficiary form say? Now, what happens is this: you have wills. You get them done, and then you save them, and you put them in a certain pile or put them in a lockbox somewhere, and then you forget about them, and then you open an account here or there. You fill out their forms, or sometimes the person you open the account with will just write out your beneficiary form, and things happen that might be a mistake. So Kevin Bress, he's an attorney at Bress Route Law. I have to ask you this question. Have you ever seen anything messed up before?
It's interesting, Brian, because it's not messing it up on the first section of the form.
Sure. Okay.
So they name their 3 children logically as their beneficiaries.
Sure.
What they're failing to think through, and that's the job of the lawyer, let's think this through, is what if one of those child passes away?
Sure.
Does the form allow a contingent? Some forms don't even get to that, or they didn't print page 2 of the form.
Sure.
So they didn't get to that. They just put their 3 children. That's where the mistakes start happening.
Okay. Now, beneficiary forms or will, which one? Like if we go and we have a will that says something and a beneficiary for it says something, which one wins in the argument?
Yeah, think of the will as in the circus, the safety net that catches the guy who falls off the trapeze.
Sure.
The will catches everything that's left after beneficiary and joint owners take their share.
Okay. So the will are instructions to probate, things that go through probate. If it has a beneficiary, it's going to avoid probate. How do we explain that to people?
Well, think of life insurance. That's always my first example is somebody dies, you fill out a claim, you attach a death certificate, and within 10 days you have a check. Probate, 6 months, 8 months, 10 months.
Right. And probate, having instructions is the will. The will tells the probate court, the register of the wills, what to go, who the money goes to, things like that, right?
Right. It just follows a much more detailed governmental procedure.
Yeah. So when I have talks like this with lawyers or with really anybody, when I think about beneficiaries, the first thing I want to know is who is the beneficiary? And so one of the things for new clients is we ask you to check your beneficiaries, to get it in writing from the different companies you have your money, to see what's set up now. Now, if someone has a beneficiary and it just writes estate in there, what's your opinion of that?
They really just drew a big circle. And
circle, okay.
They said, I'm going to use a beneficiary form, then I'm going to give it back to my estate. Yeah. And the will's going to govern it, which is fine, but that's probably not what they meant.
If you have a will, it'd be really nice. If you do that and not have a will, is what I've seen.
Yeah.
So the typical thing is this: they have auto and homeowners insurance. That agent sold them a policy. They wrote estate as beneficiary. Even the primary, and I've seen this a few times. They wrote estate, and then when they bring it in, we review. I said, well, does your spouse want this money? I said, do you guys have wills? No. So this is a mess.
Yes.
Because the idea of how you write your beneficiary, making that the priority of everything, it's so important to make sure it all works together for your wishes to actually happen.
And I have a good point on that, Brian. If a client comes in and they say, I did a beneficiary designation on that, I'd say, when? I don't know, 10 years ago. I'd say, do another one.
Yep.
And they'd say, what do you mean? I said, Do you have a copy of it? Do you know that the company didn't lose it? Do you know it's still in effect? Yeah. Just do a new one, and that way you freshen it up.
Did that company change their website? Did they change their technology?
They merged.
They changed their name. What happened there? All right, so we've been talking about legacy and the planning, and then I got to get into charity. We teased about the donor advised funds and about the use of a donor advised fund. And the thing that you made it sound very simple is this. Instead of setting up a foundation to put money in and then managing it that way, typically a foundation, you want to have a minimum of $250,000 or higher before you even want to talk about a foundation. But a donor advised fund can be started very small. It could be $5,000-$10,000. And what happens is through proper 501c3s, you can give to those charities from your donor advised fund because you put the money, it's invested, and then money goes out to the charities that you designate.
And it goes out when you want, not immediately. So you could build up your fund. Let's say your children are going to inherit running your donor advised fund.
Sure.
They get to select year to year how much they want to give out. Mm-hmm. And they do it through one of these big investment houses like a Schwab or a Fidelity or something.
Exactly
like that.
Right. And that's what we've been doing with having these donor advised funds custodied. We manage the money, and then we have the meetings each year saying, where do you want it to go? Now, this money, of course, is money that you put in after tax, goes in. You get a tax deduction because you're giving to a charity. Your family does not get that money back. It's going to charity. It's going to be distributed over time based on the rules of the plan. And you can set up basically 501c3 is properly registered nonprofits. You just can't put the money in there and then give it to your grandkid. It's going to have to go to a charity.
Right. And the donor, the parent dying, could say, I'd like this donor advised fund. They're saying it to their children. Use it for charities that favor animals, for example. So they get to pick Humane Society or...
Absolutely.
Yeah.
Now, charity in a will is another way of avoiding taxes. Charity in the will is going to divide money up. Now, one of the things about beneficiary forms and charity that I found is if you have a beneficiary form where all the money goes to the kids, but your will says, I want to give 10% to a charity, how do we make that work mathematically when all your beneficiaries are sending all the money to the family and nothing's actually going through the will?
Well, what's worse is you have the charity camping out in your yard in a tent waiting for their money, and they're just never going to get it because, like you said, the money didn't fund the will. Mm-hmm. And that's a concept, Brian, I find I've got to sketch it on paper for people because it's too abstract, especially on radio, to sort of...
Draw that up on radio for me.
Right. So we need a TV show.
Yeah, someday. So the idea is this, is you want money to go to certain beneficiaries. If it's a charity or individual people, family, and you want to control all those things, we do that through properly done wills, estate planning, trusts, whatever is needed to provide what you want to see happening. The goal here is legacy. What's your purpose with your money? What do you want your money to do for you? What do you want your money to do for others? That's very important. Then we can figure out, do we do it now? Do we do it later? I love the idea of doing qualified charitable distributions as we get to 70 and a half, where we can use your IRA money and give it to charity. I love that a lot. It's a very good way of giving money and not paying tax today.
Oh, it's fantastic, and I forget about it a lot because it just doesn't come up in normal conversation. But thank goodness you're catching those situations that are good for it.
Yeah, we enjoy doing that for people. We also use beneficiary IRAs when somebody's over 70 and a half to be able to basically, if their parent gave them an IRA, instead of them paying tax on it, they could give to their parent's favorite charity. So it's a combination answer. Not too bad.
Right.
All right. So today's show is called Legacy and Charitable Giving. The reason we brought both together is that legacy is your purpose and what you want to do. It could be family. It could be other things that you want to accomplish. It could be charity, and it could be either. It could be both. It could be a combination. Whatever that plan is, let's do something to make it happen. The plan is your legacy. That's a very important piece to get out of this. The plan is your legacy, and the lawyer is how we get it done, right, Kevin?
Brian, had a case mature, meaning sadly the client died. Yeah. It was a will I did, I'm going to say 10 years ago, forgot all about it. Mm-hmm. And we read that will now, and oh my gosh, this is the only client ever did something like this. They set a trust up for the grandchildren, and they said they want an annual distribution on the date the grandparents got married.
Okay.
So that the grandchildren would forever know that was the anniversary date of the grandparents, and they'd get a cash distribution from the trust. That's a legacy.
Yeah, well, there's a comment saying that we could die 3 times. One of them is when we actually die. One is when you're they forget about you, and the other one's when the money runs out.
That's good.
But the hard part is this: you have to do planning, and the thing that we like to do is invite you to do it with us. You can do it through Kevin and his law firm. You can do it through Akers Financial Group. Just give us a call, go to our websites, check us out, and then let's begin that process. Kevin, thank you very much for a great show.
Thanks, Brian.
I'm going to undo that seatbelt so we can let you out the door here.
Yes.
I'm sorry it has to end so quickly. You can always remember the times by going to our website at akersfinancialgroup.com to the radio podcast file right there and listen to any of these shows that we have set up there. We do look forward to meeting with you. We want you to win in your retirement by taking advantage of the opportunity to begin planning with us at Akers Financial Group. To schedule a free meeting with one of our team of advisors, go to our website at akersfinancialgroup.com, scroll to the schedule meeting section, and let us know you'd like to schedule your meeting right there. That's akersfinancialgroup.com, or you can call us at 833-WIN-RETIRE. That's 833-WIN-RETIRE. We'll give you a call on Monday to schedule a free in-person meeting with one of our team of advisors. Start planning for your retirement now. Go to akersfinancialgroup.com or call us at 833-946-7384. Thank you for listening. I'm Brian Akers from Akers Financial Group, and we want you to be winning in retirement.
You've been listening to Winning in Retirement with your host, Brian Akers of Akers Financial Group. Akers Financial Group offers securities through Archedios Capital, an SIPC and FINRA member firm. Advisory services are provided through Archedios Wealth. Akers Financial Group and Archedios do not share any common ownership. Neither Archedios nor Akers Financial Group provides tax or legal advice. Advice given on winning in retirement is general in nature, and one should seek further advice from their financial advisor, broker, attorney, and or tax accountant before investing. Be sure to read each prospectus carefully to understand all the risks associated with each investment. Examples and scenarios shared are meant to be for illustrative purposes only. Past performance is not indicative of future results.